40. Don't bother bringing the Constitution to traffic court. Whose car is it? By Agitarox at Banet. Net. Lots of people wind up in traffic court at one time or another. Most people just pay their tickets to avoid going there in the first place, most of the rest wind up paying no matter what their defense might be. However, an obstinate few will bring up their rights recognized by the Constitution as a part of their defense, sometimes in relation to the actual charge, sometimes in relation to the way the court handles the case itself. My advice. Don't bother bringing up the Constitution in traffic court. Why? Because in my opinion, the Constitution is irrelevant. More than once I've heard people tell stories of exasperated judges warning the hosees appearing in that court that if they mentioned the Constitution one more time, they'd be found in contempt of court. How could the Constitution not be relevant in a court, you ask? Well, if the case at hand was a matter of law, and it involved your property, and you weren't involved in a Star Chamber extortion mill proceeding, the Constitution might be relevant. Unfortunately for you, traffic cases don't involve law, it don't involve your property, and when entering traffic court, you've stepped onto a conveyor belt designed and operated to part you from your money. The astute observer will have noticed at least two issues in that last statement that don't jibe with conventional thought. Allow me to examine them in a little detail. Are you sure it's your car? The first issue is whether this traffic incident actually involves what you think is your property, your car. But are you sure it's your car? You bought the car brand spanking new from your local dealer and finally paid off the bank note. What a nice feeling to get that envelope in the mail with that certificate of title marked paid. Ah, it's Miller time. But before you get too comfortable and break out the potato. Anti-Shyster News Magazine Volume 11, Number 1 www.antishyster.com a-at gte.net 972-418-8993. Chips, let's look at what happened over the last 48 months. When you bought the car, what did you do? You wrote a check for the down payment. When the car arrived at the dealer's lot, you wanted to drive it now, so you let the dealer title it with the state. Naturally, since you still owe a lot of money on that car, the bank got the certificate of title until you paid off the loan. Stop. Think about what just happened. What's a FRN? First, you cut a down payment check to be paid in Federal Reserve notes. Since I started talking about the Constitution, let's examine what FRNs are. First, I'll tell you what they aren't. They aren't money. They may be legal tender for all debts, public and private, but they aren't money. Debts can only be paid with money, lawful money, i.e., gold and silver coins of the United States of America per 12 U.S.C. 152. So you didn't really pay off that loan, you merely discharged that debt with a negotiable instrument of debt, FRNS. So you didn't really pay that debt, you merely discharged it. If you didn't really pay for your car, how can you claim to own it? T was your car. Sort of. The next thing you did was let the dealer title your car since you wanted to drive that new car off the lot now, not later. What exactly happens there? Dealer took the manufacturer's statement of origin MSO, which was the first piece of paper constituting legal evidence of ownership of the car, and gave it to the state. POLICESTATE. Ronning. 2007. Coast to Coast, U.S. Marine Corps, local police and NDT and NNT raid and aim. Join Alex as he takes you on scene and interviews those training to enforce America's police state. Police State 2000. This 2-hour video is only $29.00 plus $3 shipping from the Silent Point 45. P.O. Box 4588, Santa Rosa, California, 954024588. Phone 707-523-1434. Think about that. Here you are, authorizing the dealer to take the only evidence of ownership associated with that car and donate it to the government. Our humble catalog is free upon request. What does the state give the dealer in return for that document of ownership? They give him a certificate of title, evidence that a title exists, but not the title itself, and not a document showing that you have the actual absolute right, title, and interest in that car. You got a piece of paper that has your name on it, their name on it, and the word owner is next to your name. You own it, right? The certificate of title is merely evidence that a title exists. Someone in the state government has signed a document that certifies that a title exists somewhere. Hence, the document is called a certificate of title rather than a title. There are a dozen different ways to legally define ownership, but the one we're concerned with here involves the bare legal owner. http://www.silent45.com Anti-Shyster News Magazine Volume 11, Number 1 www.antishyster.com a-at-gte.net 972-418-8993 41. 42. Ship in the form of a possessory right. You may have physical possession of the car, but that doesn't necessarily mean you own it the way you think of the concept of ownership. What is the true title for that car? The manufacturer's statement of origin, the MSO, an actual attested legal document prepared by the manufacturer stating that they created the car, manufactured it, and therefore own it until they sell it. The next owner can prove his true ownership of the new car in law by possession of the MSO and a bill of sale. What was the document showing ownership or title of the car during the time between when the manufacturer built and owned it and the dealer sold it to you? The MSO. If the MSO is only an indication of what type of car it is, what year it was made, or other sundry descriptive information, why would the state be so concerned with receiving and obtaining it? If the MSO is not the legal title, why wouldn't simply showing the MSO to the state suffice? Why is the state so concerned that the certificate of title be printed on archival grade, fraud-resistant, security-featured document paper, the kind normally reserved for legal documents like stock certificates and titles to homes and land? Why do they insist on the delivery and retention of the original MSO? Why wouldn't a court-certified copy do? Or an official notice from the manufacturer? Isn't the point of the MSO to simply to show that the car that was delivered to you is new and that you own it? In fact, if you march down to a court reporter, notary public judge with the dealer and have the reporter authority certify under oath that the MSO that you hold is the original, have the dealer affirm under oath in an affidavit that he delivered the original MSO to you, and you then bring a court-certified copy of that MSO to the Department of Motor Vehicles to title it, they still won't take it. Why? Because they need the original MSO to effect a transfer of actual title to them, to the state. They then issue you a certificate of title, which merely evidences that a transfer took place, that an AC tool titled as XIST, an AT, and that while they hold actual title and therefore legal ownership of the car, you have bare legal possession the car. So who is it that really owns your car? Your car goes into a trust. Okay, so now the state owns your car. So what? Well, here's what. What's the first thing you let that dealer do after he got your car titled? He registered it. What's wrong with that? You have to understand how registration affects the status of property, and you have to understand the concept of trusts. A trust is a situation where property is held by legal entity for the benefit of another. That property may or may not be in the physical possession of a trustee of the trust. No matter who has physical possession of the property, it is subject to the terms of the trust. Anyone having physical possession of trust assets has a fiduciary duty to maintain or improve the assets of that trust for the benefit of whoever holds interest in the trust. Anti-Shyster News Magazine Volume 11, No. 1 www.antishyster.com a-at-gte.net 972-418-8993 The terms of a trust or its constitution. While the federal constitution involves law, the terms of a trust involve private law or contract law that will be litigated in courts of equity. Incidentally, who owns and operates the courts of equity? The same state that owns legal title to your car. Should we be surprised if the state's courts routinely ruled in favor of the state? What is required to create a trust? Massachusetts law is probably representative of most states' law on trust creation. In Massachusetts, there are 3 legal requirements to create a trust. 1. A written transfer of the property to another person, containing a description of the property. 2. The names of at least 3 parties involved. A. Creator transferor of the trust. B. Custodial trustee of the trust. C. Beneficiary of the trust. 3. An evidencing of the creation of a trust by a registration of the property. Check it out. according to the Massachusetts General Laws. 2. Uniform Custodial Trust Act. S. 1852 generally, creation 14 Mass. URDECEDENTS, estates and trusts. A person may create a custodial trust of property by a written transfer of the property to another or another person, evidenced by registration or by other instrument of transfer, executed in any lawful manner, naming as beneficiary an individual who may be the transferor, in which the transferee is designated, in substance, as custodial trustee. 95. Emphasis added. If you read Section 1852 carefully, you'll notice two terms that are easily misunderstood or overlooked: person and individual. The average person wouldn't dream that the meanings of person or individual could include government, but the average person would be WRONNNNNNG. Both person and individual can be used to identify a legal. In all Chicagoland, there's only one Stonebridge Village. Apartments and penthouses. A complex of 586 large apartments in a 45-acre, beautifully landscaped park-like setting. 10 minutes from convenient shopping at Woodfield Mall. Only 45 minutes from the Chicago Loop. Luxurious and innovative living accommodations plus a full range of recreational facilities for you to enjoy, and now offering new RRGALSURTES. 600 Rand Road, Arlington Heights, Illinois, 60004708-394-3434. Anti-Shyster News Magazine Volume 11, Number 1 www.antishyster.com a-at-gte.net 972-418-8993. 43. 44. Fiction such as corporate state government. Look them up in Black's Law Dictionary to see what I mean. Notice also that the creation of the trust is evidenced by registration of the property. What did you do with that car after you gave the title to the state? You registered it. By registering the car, you effectively created a trust wherein the state owns legal title to the car and you merely retain equitable title possession. The Uniform Custodial Trust Act continues. A person may create a custodial trust of property by a written declaration, evidenced by registration of the property or by other instrument of declaration executed in any lawful manner, describing the property and naming as beneficiary an individual other than the declarant. A registration or other declaration of trust for the sole benefit of the declarant will not constitute a custodial trust. 96. Title to custodial trustee property will be in the custodial trustee and the beneficial interest will be in the beneficiary. 97. Any person may augment existing custodial trust property by the addition of other property pursuant to the Act. 98. The Uniform Custodial Trust Act will not displace or restrict other means of creating trusts. A trust whose terms do not conform to the Act may be enforceable according to its terms under other law. 99. Emphasis added. Notice also this section. C. 201 C Sec. 1. Transfer to statutory custodianship. Trustee. An adult person may, during his lifetime, transfer any property owned by him, in any manner otherwise consistent with law, to one or more named persons designated, in substance, as a statutory custodianship trustee. Such transfer shall be sufficient to create a trust upon the terms set forth in this chapter as it is in effect at the date of the transfer without any further trust instrument or designation of terms and without appointment or qualification by any court, and shall be complete upon acceptance of the trust by the trustee or trustees manifested in any form. The trustee or trustees shall serve without giving bond or surety unless the transferor by written instrument, or the probate court upon the application of any person interested in the estate of the transferor and upon good cause shown, shall provide for a bond. All transfers in trust under this chapter shall be revocable by the transferor at any he has legal capacity by a writing signed by him delivered to the person, or if more than one to any person serving as trustee. Emphasis added. Thus, it appears to me that after donating the title MSO to your car to the state, a constructive trust is created. But don't take my word for it. Look up the exact definition of Anti-Shyster News Magazine Volume 11, Number 1 www.antishyster.com a-at-gte.net 972-418-8993. Constructive trust, in a law dictionary. You have unwittingly succumbed to the deceit of the manufacturer, dealer in state government and transferred title MSO to property you supposedly own to the state or its agent. You then register the property, which is all that is necessary to create a trust. Remember that it says, a person may create a custodial trust of property by a written declaration, evidenced by registration of the property or by other instrument of declaration executed in any lawful manner, describing the property and naming as beneficiary an individual other than the declarant. Remember that registration wouldn't constitute the creation of a trust if the document only had your name on it. See item 96 above. Usually, that, title, and registration, application and document have a. Your name. B. The name of the state and motor vehicle agency representing the state you're dealing with, and finally, C. The signature and/or seal of the head of that agency. So there are the requisite number of entities or person named on the documents to create a trust. You unknowingly created the trust by transferring legal title, but not possession equitable title, of the property to the agency head named on the certificate of title registration. Usually, this person's signature or seal is included on the document. Take a look at yours and see. The state DMV agency. Anyone can legally stop paying income taxes. You go to court and thousands of Americans already have. For a 2-hour video detailing how anyone can legally stop paying income taxes, send a check or money order for $49.95 plus $3 S&H to Stephen A. Swan, Income Tax Patriot, P.O. Box 453, Auburn, NH 03032. For more information, go to www.zeroincomeattax.com for a free brochure. Call 603-483-0550. Names you as owner, although you only have ownership in the form of bare legal possession of the car. You don't have all right, title, and interest in the car, just bare legal possession. As beneficiary to this auto trust, you are also placed in a fiduciary capacity to make sure that your car is well maintained and operated safely under the rules of the owner state. So what happens when you get a ticket for a defective tail light? You start whining that nobody was hurt and, under the Constitution, the common law says that there has to be an injured party and you demand the state produce the injured party. Whereupon, the judge says, shut up and don't mention that Constitution again or I'll throw you in jail for contempt. You're scratching your head, but the judge is right. He's enforcing the terms of a constructive trust that you helped to create. Trusts. Anti-Shyster News Magazine Volume 11. Number 1 www.antishyster.com adask@gte.net 972-418-8993. 45. 46. Are private contractual agreements and operate outside of the law and generally have nothing to do with the Constitution. Thus, your constitutional defense was irrelevant. You have a fiduciary duty to the owner state to keep that car in tip-top shape, and you screwed up when you let the tail light burn out on the car the state has been kind enough to let you use. It doesn't matter that nobody was hurt, and the judge will toss your butt in the can if you keep bringing up that damned common law and constitution. On. Homework. There's one last thing the sharper readers may have noticed. The end of c. 201c sec. 1 reads, all transfers in trust under this chapter shall be revocable by the transferor at any time he has legal CAPA City BYA writing signed by him and delivered to the person, or if more than one, to any person serving as trustee. Crime Speak 2001. What you know can kill you. If the government knows you know. By former member of NSA's Military Intelligence and Baltimore PD. http://www.crimespeak2001.tripod.com. Email, crimespeak2001@yahoo.com. Here's today's homework assignment. Figure out 1. What it means to have legal capacity, 2. What it is that you have to say in that writing, and 3. To whom you have to present your legal writing. Hint. Search MUR 2. If you could learn how to revoke the transfers under the auto trust to your car, you might be able to regain legal title and real ownership to your car. There's one other tactic that CUCTNAT might defeat the judge's silent JT judicial notice and presumption of trust. Let's say you return your certificate of title to the state along with your registration utilizing the forms prescribed for that purpose. You can't very well claim that you own your car when you're holding evidence that the state owns in your wallet. In truth, the certificate of title and registration don't prove you do own your car, they prove you don't. What if you were to publish a legal notice 3 times, over 3 consecutive weeks, in a newspaper of wide circulation in your area that looked something like this? Parties claiming interest in property IEs 11984, AMC, Jeep, J7, VIN number, 1,234,567,890,987,654,321 and or 2,1987. Chev, Blazer, S10, VIN number, 1,234,567,890,987,654,321 must state interest by March 30, 2001 by replying at Box 1234, Any County News, Anytown, Ta. According to Black's Law Dictionary 6th edition, the term interest means, but is not limited to, an instrument of security by hypothecation. Anti-Shyster News Magazine Volume 11, Ing. 1 www.antishyster.com a-at-gte.net 972-418-8993. 2. Claim. Adverse, equitable, legal, marketable. 3. Interest. Adverse, equitable, legal. 4. Ownership. Adverse, equitable, legal, possessory. 5. Right. Adverse, equitable, legal, possessory. 6. Presumption by statute. 7. Subject by trust. Constructive, de sun tort, ex delicto, ex maleficio, implied, involuntary. 10. Subject of bankruptcy. 8. Title. Adverse, equitable, legal, marketable. 9. Interest resulting by trust defined in law. Private, public, ternational, federal, general laws of the People's Republic of Taxicusets, statutes. 11. Interest by operation of law. Private, public, international, federal, general laws of the People's Republic of Taxicusets, statutes, 121 lien or encumbrance. 1 to 800. Then, if you were stopped for a ticket, what would happen if you motioned a court for a declaratory judgment stating that by virtue of beat IRS claims of interest being stated I pursuant by your notice, you have know your $100,000 plus opportunity, absolute right, title, and interest in those properties. Do you think they'd submit evidence that they actually own your and everyone else's car to refute your claim of ownership? They might, but would they? Rights. Product sold only through doctors for 16 years. International company sends out free sponsoring packet for you. CEO has taken 2 other companies to $1 billion in sales. Civil and criminal tax. For information call. Eliminate tax debts through bankruptcy. In www.beaters.com. Anti-Shyster News Magazine. A final note for those annoying constitutionalists. For all of those constitutionalists who have the temerity to think they have a right to travel with their private property without first getting permission from the state, remember that the judge always takes silent judicial notice that you're driving one of the state's cars, regardless of whether the registration is current or even exists or whether you returned their certificate of title. Until you regain the MSO or get their court to recognize that your car is, in fact and in their law, yours, you're just whistling Dixie. 888-493-8024. Volume 11, Na. 1 www.antishyster.com a-at-gte.net 972-418-8993. 47.